5, 4, 3, 2, 1. The learned senior counsel vehemently submits that the instant case is of such a nature where, by any stretch of imagination, criminal proceedings could not be initiated, as the dispute is purely of civil nature, and even if the allegation of the FIR is taken on its face value, the same appears to be a case of breach of promise or contract, on the basis of which only civil case could have been filed. It is further submitted that there were no sufficient ground before the magistrate to summon the applicant to face trial, and the magistrate has materially erred in summoning the applicant to face trial. It is further submitted that the cognizance has been taken by the magistrate without application of judicial mind, and the order of taking cognizance and summoning the accused has been passed on pro forma simply by filling up the blanks, which reveals that the magistrate has not applied his judicial mind. It is further submitted that the proceedings before the courts below are nothing but the abuse of the process of law, and therefore the same may be quashed. Learned senior counsel relied on a judgment of this court dated 14/11/2016, passed in petition 482 CRPC number 3567 of 2008, Devbhanu versus State of UP. Learned additional government advocate for state, while controverting the arguments of the learned counsel for applicant, submits that the arguments of learned counsel for applicant is with regard to the factual aspects of the case which cannot be gone into by this court while exercising jurisdiction under section 482 CRPC. Having heard learned counsel for the parties and having perused the record, it is now no more res integra, and this court, in the exercise of its jurisdiction under section 482 of the Code of Criminal Procedure, is required to examine whether the averments in the FIR complaint constitute the ingredients necessary for an offence alleged under the Penal Code. If the averments taken on their face do not constitute the ingredients necessary for the offence, the criminal proceedings may be quashed under section 482. A criminal proceeding can be quashed where the allegations made in the FIR complaint do not disclose the commission of an offence under the Penal Code. The FIR complaint must be examined as a whole without evaluating the merits of the allegations. Though the law does not require that the FIR complaint reproduce the legal ingredients of the offence in verbatim, but the complaint must contain the basic facts necessary for making out an offence under the Penal Code. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.